Hello and welcome to the Three Questions podcast, where we dive deep into the world of wealth management and connect you with industry experts. I'm your host, Wayne Baxter, Senior Executive Manager at One Capital Management. Now, are you or someone close to you currently living in the United States and considering a move back to Canada? Well, you're not going to want to miss this week's episode. What's our topic? It's the three questions Canadians relocating back to Canada from the US should ask about estate planning. Thank you for taking time to check us out. And if you enjoy this episode of the Three Questions podcast, please consider liking this video and subscribing to our podcast and YouTube channels. In 2025, many Canadians are returning from the US to Canada due to factors like proximity to family, access to universal health care, lower costs in certain regions anyway. There's cultural familiarity and also concerns over US political or even economic instability. We have over 50,000 Canadians, according to StatsCan, repatriating back to Canada. Now, for the high net worth individuals, this move can often involve optimizing tax efficiencies, such as Canada's lack of federal estate tax. There's deemed distribution rules on worldwide assets upon death. And that makes estate planning a really important, critical step to avoid, double taxation or even probate delays, which is everybody's nightmare, especially here in California. Challenges including reconciling U.S. revocable trusts, ensuring power of attorneys are valid across borders, and addressing U.S. estate tax on retained assets like real estate or investments to protect these legacies and minimize liabilities. Quite a lot to deal with. So we're going to focus today on the three questions Canadians relocating back to Canada from the U.S. should ask about estate planning. And joining us from Calgary, Alberta, is Craig Tervit. He is the founder of The Last Word, a Canadian estate planning law firm dedicated to helping clients craft comprehensive wills and estate plans that reflect their unique wishes and minimize family conflicts. And I'll tell you, that last part is a task sometimes. Craig, great to see you again. Thank you for joining the podcast.
Thanks so much. It's great to be here. I've been listening to a lot of the podcast and excited to be here today.
Right on. Well, really appreciate it. And keeping families from becoming adversaries in this as an estate planning, from an estate planning attorney's perspective, is not an easy task. That's for sure. Okay, before we get to our three questions, I thought maybe we could start the podcast off with just you sharing a little bit about your work at The Last Word. And from your point of view, why is estate planning so crucial for Canadians who are relocating from the United States back to Canada?
Yeah, so thanks very much. The work that I do at The Last Word, started up myself over 10 years ago and just realized that estate planning is something that often gets overlooked to great detriment, whether it's a family dynamic issue or an issue to do with, paying extra taxes, delays, etc. Kind of as you mentioned. We focus exclusively on that area of the law. We only do wills and estate planning, trusts and that kind of adjacent work. And I find it endlessly interesting. So I really enjoy getting into that area. You know, One of the reasons this is an especially important thing to do and look into if you are returning to Canada, I would say realistically, it's always important, regardless of whether your situation is that you're returning here, you're going somewhere else, if you're staying
Or
where
you've
you
never
are.
been anywhere and you're not going anywhere for that matter.
Exactly. All of us are going somewhere eventually. You know what I mean?
Fair enough.
So that's the important thing. But I think that one of the major things that happens when people are moving between Canada and the US, whether it's moving back or moving one way for the first time, often everything seems so familiar. There's so many similarities between Canada and the US, despite occasional differences. But it's not like comparing Canada to France or Quebec, for example, where there's a different system of law or different sort of traditions around who you leave your estate to, etc. It's all very, very familiar. And with that familiarity, it's very easy to overlook the things that are very different and very important not to miss. So suddenly, I'll talk to someone and they're like, well, I didn't think this would really be an issue. I haven't really done any estate planning around my move. And, that can have major consequences.
So the focus of the episode here we're doing today is on Canadians returning to Canada. But I gotta ask, I'm just more curious than anything. Are you okay, in the context of your own practice here, I'm not expecting you to do national surveys or anything like that, uh, but are you finding that you're seeing American citizens are also looking to relocate to Canada? So in other words, it's not just Canadians coming back to Canada, but you're also running to Americans who are saying, you know what, I want to move to Alberta or I want to move to BC, Okanagan Valley or could be Vancouver, Vancouver Island. We all know is very popular. Calgary, uh,
For sure.
good Lord, Canmore, Alberta. I mean, I lived in Banff, Alberta. I think I probably mentioned this on the podcast. I lived in Banff, Alberta back in the 1980s for 6 years. And I don't know if I told you this, we had breakfast there a few weeks ago, but I lived in Banff for 6 years, Craig,
Hmm.
and I moved to Toronto. And I was literally, no exaggeration, homesick for Banff for another 6 years. If I saw Banff on TV, I'd almost start crying. I love that place so much and made friends that are friends of mine to this day. But yeah, so are you seeing, you're running into, American clients that said, yeah, we're moving up to Canada. Working with an immigration attorney and we need help with our estate plan. Or is it mainly in your case dealing with Canadians making the move back?
No, it's definitely both. I think there's maybe two different scenarios that are fairly common. With Alberta, it tends to be that oil field pipeline of and associated industries. Where if you work in Texas, you might be moving up to Alberta. If you work in Alberta, you might be moving down there. Same clients, same group of clients are frequently, maybe moving to the UAE or something like that, Saudi Arabia, etc. There's a fair amount of movement that way with transfers or new opportunities, and so that's fairly common. So we see Canadians going down there, them coming back up. In terms of Canadians moving up to Canada, I do find that quite often. Um, or sorry, Americans moving up to Canada, that quite frequently, if you live anywhere other than the sort of Minnesotas of the U.S., that BC is maybe your entry point so you don't have to deal with -20, -30 for an ongoing extended period of time. So I myself actually came here from South Africa when I was little, and I think it was a big. We moved to Vancouver because it was something where you could do that, and it was a huge change in temperature anyways, but it wasn't quite the same extremes as moving to the prairies and that kind of experience.
Yeah, it's a dry cold.
Yeah,
That's
it
that,
is sunny. I'll give you that. Sunny and -20, -30, but
and there's nothing like a Chinook.
that's true. Yeah.
Okay, I got my friend Kira here. Have you ever heard of a Chinook? Look it up on your phone. Chinook is a thing. You've never been in Alberta. A Chinook is the most beautiful thing. And the first time I experienced one, I couldn't believe it because, you know, middle of the winter time is -20 Celsius, which is cold. And then the next day you look out the window and there are people walking around in t-shirts and shorts, and it's like, what? What happened? What? And then it's like it's going to be here forever, right? And then 2 days later, -20,
Yeah.
-30 again. So it's
You
look
gotta enjoy it while it's there.
100%. Okay,
Yeah.
so purpose of the episode isn't to talk about Chinooks, although God bless them. We're here to discuss the three questions Canadians should ask about estate planning when they return from the United States. That's the episode today. Now I'm going to hit you with question number one right off. You ready to go, Craig?
Let's do it.
Okay. Question number one. We recently moved back to Canada from Texas. We were just talking about Texas, and are living in Calgary. Do we need to keep the revocable trust in place? And can we continue to hold our investment account in that trust? So they're formerly Texas resident. They have a revocable trust set up. They've got their investment account in there. Now they've moved back to Canada.
So I'm going to give you the most lawyery answer
It
possible, which is
depends.
yes, exactly. So it really does depend. A lot of it depends on what the plan is. Like, are they here for a period of time, maintaining U.S. assets? Is the plan long term to move everything up here? Is the plan to move back down to the U.S. at some point? So the plan can really affect things. With the revocable trust, you got to keep in mind that the CRA will look at where the care and control of the trust is in terms of determining where it's resident. So if you're the trustee, which is typical in these kinds of scenarios, then they could deem it to be a Canadian resident trust if you've moved back up here. And that can cause all kinds of problems. So, there may be some adjustments that need to be made. It may be much more complicated than is necessary if it's relatively small or relative, not an enormous number in terms of the value of the assets in the trust. With that said, if it's really substantial and if there's been a lot of growth there and it's something that you want to maintain, either for specific tax reasons around what it'll cost to deal with it and move it up to Canada, or because long term there's a plan there, then the discussion is more around how do we adjust the trust to make sure that you're not going to be offside of anything and that you're not going to get taxed twice or dealing with Canadian deemed disposition rules, etc.
Okay, well, you just cracked open the door wide open to a whole bunch of follow-up questions here. So, it's amazing. The answer to it depends is, I moved down here to LA 13 years ago and got into the legal community here, met a lot of attorneys. It was amazing how many times every question I would have would start with "it depends." So you're in the community without even being here. Okay, so first question. So if okay, in the scenario where retaining the revocable trust makes sense, for certain assets,
Yeah.
first question, what are the tax implications for the returnees? And I have another question on top of that, so I'm going to bombard you here. So bear with me. You mentioned about how it's sort of the trust is looked at to see how it's quantified. So if the successor trustee, so in the US, just for folks listening in Canada, you'll name yourselves. Typically, the husband and wife will, under this scenario, will say husband and wife are sort of the primary trustees of the trust, but then typically it's suggested or highly recommended that you name a successor trustee. So let's say that, and it ought to be a resident of the United States. You do not want to have a Canadian successor trustee for a U.S. trust. It's not a good thing. It turns it into a foreign trust. So let's say they did name a U.S. successor trustee. How does that impact the decision-making process when the initial, husband and wife, original trustees move back to Canada? Does that having that U.S. successor trustee make it easier to keep the trust domiciled in the U.S. from either a U.S. or a Canadian perspective?
So in terms of that, it all goes back to that care and control. So if you are staying on as the trustee of that trust, and typically, when you set it up, that's the preferred way of doing it. You want to still maintain control over those assets.
Right.
But if you're moving up here and, there's no way of being able to argue that the care and control somehow was being more in the US. Like there are people where they go back and forth quite a bit and they have potentially the ability to say that, well, actually, the bulk of the actions, the care and control are being done down there. But if you can't do that, you're going to be in a position where you really, might want to consider having that successor trustee maybe taking over the trust down there as an option.
As long
You
as you have
know,
a really good relationship with them.
exactly, yeah.
Yeah.
And so, it's not the way you would set up the reasons you set up the trust when you did. Um, is because it's a very convenient and easy way of dealing with those assets, avoiding probate, limiting taxes. A lot of those are they're not negated, but it's not quite as simple when you're moving back to Canada now, right? So it's a matter of really looking at each asset one by one, deciding if it makes sense to keep it, sell it, keep it in the trust, transfer it into your name personally, something along those lines, and just making a judgment call on each asset line by line, really to make sure that you're getting the most out of your tax situation, making sure the beneficiaries are the right people, etc.
Well, okay. So, like I said, we unpacked quite a bit there. So, um, our topic today is the three questions Canadians relocating back to Canada from the US should ask about estate planning. And joining us from Calgary, Alberta is Craig Tervit. He is the founder of The Last Word, and his law firm assists clients in crafting comprehensive wills and estate plans. That's what they do. So, that first question was a biggie. And guess what? We have a follow-up question to the last question. So it's even more. So, as a follow-up to our previous question, do we need separate powers of attorney for the assets left behind in the US?
Um, and that one actually is quite easy, I can say definitively yes. It's always a good idea to have a power of attorney for your US assets and a separate power of attorney for your Canadian assets. Um,
And
First of
that's
all,
applicable whether you're in either country. I mean, you could make the same argument if you're a resident of the States and you got a condo up in Calgary or Vancouver or the Okanagan Valley, you'd want to have a will for that property in Canada and power of attorneys as well.
yeah, so
I'm not an
typically we're
attorney and
looking
I
at
don't play one on TV, but that one I think I've got pretty much figured out.
exactly. And there's different levels to this. So to some extent, um, oftentimes you want to name someone who's local to be in that role. Um, the other side of it is that having a Canadian power of attorney for use in Canada can be helpful in terms of sometimes, even though a power of attorney is supposed to be accepted by banks or whoever you're dealing with, they see something that's unfamiliar, something they're not used to dealing with. Even if eventually, after a bunch of letters back and forth with the lawyer, they'll accept it, it's so much easier just to get something specific that's local, familiar to the local authorities, so that it's easily set up. Your power of attorney doesn't have to deal with any headaches of trying to convince them that it's actually, viable and legally effective. Similarly, someone who's local can also take actions that sometimes you can't otherwise. I do find that,
Yeah, the whole idea of having powers over, like you see, like in my case, like I have a lot, as I
yes,
told you,
yeah,
clients that their family are still up in Canada and they've moved to the US and they don't have those sort of long-standing relationships established yet. And so the first conversation a lot of times is, well, yeah, I know you'd like to have your sister as the trustee of your trust, but she lives in Toronto and you're in Austin, Texas, for example. It's like this is not going to work. So in those cases, what I do is I'll bring a fiduciary in to take on the role. And I often try to convince them to not only take on the role of the successor trustee part, but also the power of attorney part. And I'll
yeah,
tell you personally, that's what I did, just for my no big secret here. That's what I did with my family trust is that I have basically retained a firm in Brentwood to look after that for me. I should say hi to my friend Bernard Weston. Hi, Bernard. Um, so to look after all of that as opposed to parsing out all over the place. And that was actually something we talked about. He said, well, because I think initially we were going to name other people. And he said, why don't you just make it easy and just have sort of one sort of authority figure over? And then there's something called in the United States a trust protector. So if my friend Bernie goes off the ranch, there's a trust protector that can come in and say, what are we doing here, folks? Right. So
yeah. And I mean, to add on to that point, I mean, we have not obviously you're aware of this as well, but not quite the equivalent, but like trust companies in Canada that do a somewhat similar role. They can be very helpful in terms of, especially if you're new to somewhere, you don't have those established lists of people that you really do trust. And other times there's people where you're very established, they still don't want to name
Well,
their,
that
those
too, I was
people.
going to bring up. That's the other reason is that we don't want to get everybody involved because of we could be here until for 3 hours on all the reasons why that could be.
Yeah.
Um, so
Well, and
when
similarly, I always find, when we're talking about promoting family unity, it's sometimes a lot easier to
keeping
name.
them out of the administration of the trust.
Exactly. If everyone, it's always being the trustee, executor, power of attorney, it's a thankless job anyways. If you can have, instead of everyone fighting against each other, arguing with, who should be it, who should, whether they're doing a good job, they can all actually, get along even better when they're collectively complaining about the trustee, etc. But at least they're doing it together.
You know, just on a note on that, I will share with you as a Canadian estate planning attorney. So when I was back in Canada, running my financial planning practice in Toronto, I will confide in you that, I would have my clients bring their powers of attorneys and executors to my office, and I had a little PowerPoint presentation that would go through, the roles of an executor, the roles of a power of attorney, and it all seemed very kumbaya to me. It all seemed like perfectly logical. And then I moved down here to the US. And for the last, what, 12 years, maybe? I got to immerse myself. I know many estate planning attorneys across the United States, not just in LA, but in the Bay Area. I mean, all over the country. And I have heard more war stories about involving family members in estate planning and as a executive trustees as powers of attorney that at this point in my career, I'm almost 100% of the time encouraging my clients to not go that route. And in fact, get something similar to what I talked about earlier, a professional, dispassionate, compassionate individual to take that role on. And I was curious, and again, you don't have to agree with me as it's not a big backslapping situation here. But what is your take on this from your view in Calgary, working with clients? How do you, when that conversation comes up, what is typically how do you handle it?
Yeah, I mean, I'm the only reason that I people will not want to go down the route of hiring a professional in those roles is usually financial in nature. They're worried about the cost. But I always like to point out that, you know, you've spent your whole life building up your estate and the assets that you have. And so for the same reason that it blows my mind when people don't do any estate planning, it's also crazy that even if someone is very well equipped to take on that role, they're, have an accounting background, etc., you're still giving someone a job that quite often they've never done in their lives, and that's to deal with your money. So I tend to feel like hiring someone makes a lot of sense, and there are exceptions, and certainly there can be reasons why you might not want to take that route. But I always think it gets under, people focus on the cost, even though other executors and trustees are going to take a fee anyways, even if they're inexperienced, right?
Especially if it's a complex case and it takes them a lot of time. Uh,
Absolutely.
Absolutely correct. Just one last thing on power of attorney. So
Yeah.
when you're drafting separate power of attorneys for the U.S. assets, are there any key differences in, say, validity or in execution that Canadians should consider to ensure that they're enforceable in both countries? Is there any nuance to that?
Yeah, I mean, I always suggest getting a U.S. attorney to prepare the U.S. documents, Canadian attorney to prepare the Canadian
Very
documents.
wise,
And
very
the
wise.
main, you want to make sure there's a circumstance with wills and with power of attorneys, you might accidentally um, uh, revoke one of the other ones if you have to do it in the right way with the right wording around it. And typically, it really depends on what state you're in, what province you're in Canada, because each province in Canada has different legislation around a power of attorney. There is a sort of agreement amongst the provinces as to accepting power of attorneys from other provinces, but you run into that same issue that I was talking about in terms of if it's not local, it might look a bit different. It might seem like it's invalid until you get really deep into the weeds, and it can cause a lot of problems. I mean, similarly, just for example, between Alberta and BC, if you're trying to do, if I have a Alberta client who has assets in BC, you need a second signatory on the document. So even though they'll accept it, for example, we always just have two signatories regardless. That way, it's not a problem. So it's very important to make sure that wherever you have assets situated, you have a power of attorney that's specific to that location because everything can change a lot.
Yeah, and I would say that the way I understand it, again, this is coming from my legal friends, my attorney friends in both countries, is that the two documents, what you mentioned about having a Canadian attorney and a U.S. attorney, is essentially those two documents kind of almost have to talk to each other or acknowledge each other's existence.
Yeah, they're typically
Talking
not.
about the trust, I'm talking about not just the power of attorney, but also the trusts and the wills. They kind of have to, the Canadian documents have to acknowledge the U.S. assets, and the documents have to acknowledge the Canadian. There has to be sort of a cohesion there. They can't just have a U.S. estate plan and a Canadian estate plan that just address the assets in the home country. That's my understanding
Absolutely.
anyway.
Yeah, it's very important to make sure that it all works together, especially because maybe part of the plan might be optimized for tax reasons by doing X, Y, and Z in one country and maybe slightly differently in the other one. But there may be steps that have to be taken in each from an estate perspective to ensure that that tax planning is actually brought into effect.
All right, so I think we've got the power of attorney aspect figured out pretty well here, and we tend to seem to be on the same page that if you can potentially or possibly exclude having to include family members into the weeds of all the administration of an estate, it may be the better. Let's move on to question number 3, Craig. It goes as follows. It would appear that we'll need estate plans for both Canada and the US. How does that work? I think we started on it, but I will let you carry the ball the rest of the way into the end zone here.
Absolutely. And, I actually tend to think of it as just a larger, more comprehensive, complicated estate plan because you don't want, as you said, one to sort of invalidate the other or them to both be so siloed that, maybe we're setting up two trusts for the same minor child in two different countries. We're trying to set things up in such a way that they do talk to each other and it is one plan. It doesn't have to be that there's ongoing back and forth between the estate in the US and the estate in Canada once after you pass away, but you certainly want to make sure that it all fits under one plan. And that factors in things like, life insurance, where it's resident, who the beneficiaries are, whether it's going to a trust or an individual. Similarly, businesses, obviously those assets can have a huge impact on how things work. So, it's putting things together, usually with the help of maybe a cross-border accountant or something like that as well.
God bless the
Making
cross-border CPAs out there. I know a handful, and they're worth their weight in gold.
Yeah, their bills always seem very, very high, but try working without them, and then you'll see what
Yeah,
what costs are. So
100%.
so yeah, absolutely. Getting that kind of advice at the planning stage to make sure that everything sort of fits in, rather than doing things all on one side of the border and then treating the other side as oh, we'll just tack on a little will there and it'll be fine. You want to make sure that it's all working to achieve the same goal.
So, are there any specific, what I would call key elements, when you're thinking about cross-border estate planning, when you're trying to, like, the big focus here always is about minimizing probate fees, right? And then you have, something depending for the higher net worth families, is that the U.S. estate tax on worldwide assets. And that's especially true given the fact that Canada doesn't have an estate tax, right? So are there any like when you're dealing with a higher net worth, then maybe they've got a total net worth of say 20, $30 million, like larger net worth families. What are you looking at then when you're saying, okay, what do we got to do here to protect you again going forward?
Yeah, I mean, and first and foremost, in that circumstance, it really is a question of confirming whether currently or, at death, and obviously we don't know when that's going to be, but if there's a short-term plan to change anything, if they are US citizens or US green card holders, or if they're trying to, we do see people who choose to renounce their US citizenship for tax reasons potentially. It can make a big difference, right? Because then once that process is complete, and that process can involve a lot of tax liability in of itself. But if you
Mhm.
do that process to renounce, or if you're moving back to Canada in the circumstance we're talking about, it may be that you never were a U.S. citizen, and maybe that's not a concern. But if you're not going to be a U.S. citizen, then we don't have to worry about that, the global assets and the potential tremendous liability, the tax liability that may be coming up in terms of up to maybe 40% of the value being taxed there. If that is an issue, then we really have to look at um, ways in which we can try and get exemptions. So the resident side is very, very important, and the citizenship. The If you're not resident, it also, or sorry, not a U.S. citizen, it's also very important to just make sure what U.S. situs assets we're talking about versus Canadian, and if there's a way to adjust that calculation by maybe moving some stuff up here, etc. I know I'm sort of opening more and more questions as I mention it, but there's a lot involved.
You've just set yourself up here. I got one for you.
Okay.
Well, I got more than one. Be forewarned. Um, before we get to, I had something I was going to ask you, but before we get to that, so I'm going to give you a case study, real brief, quick.
Okay.
You have a Canadian that's moved down to the US. They've been there for under 8 years. They've managed to get themselves a green card. They have accumulated more than, say, two, maybe $3 million. And now they want to come back.
Yeah.
Uh, Now the issue there, as you know, no, pardon me, if they've been there 8 years or more, I got it backwards. So 8 years or longer, and they've accumulated over $2 million of net worth. What is your opinion on the idea of becoming a U.S. citizen before making the relocation happen? Therefore, because if they don't, they're going to have an exit tax experience they have to deal with potentially because they have gone over that threshold of time in the US and gone over the threshold of net worth. So
Right.
because if you move to the US from the US to Canada as a US citizen, there's no exit tax risk.
Hmm.
Thoughts on that idea? And
Um,
feel free to shoot it out of the sky, Craig, but your thoughts.
no, I mean it really depends on, a lot of the time when we're talking about estate planning, we're talking about varying time horizons. Like there might be actions that you can take now that have a negative consequence now, but from an estate perspective are beneficial. And you're sort of weighing those two things. When we're talking about something like that, it might depend a bit on who are the beneficiaries down the road. Are they in the US? Is that something where,
Oftentimes
uh,
they're going to be dual citizens, just out of personal experience.
yeah. And so are those beneficiaries going to be in a position where maybe those assets can transfer to them with minimal sort of taxation risk? Or if you were a US, if they go through with the US citizenship, or is it something where, and sorry, beneficiaries, I'm saying like of an estate. So if the primary person deceases, and we're talking about their kids probably, the versus the if everyone's coming up to Canada and there's no sort of likelihood of those beneficiaries being dual citizens, then it may be something where it may be worthwhile biting the bullet, so to speak, now.
Okay,
And
the exit tax.
yeah, the exit tax. Um, it's a bit of a complicated calculation, but it's certainly not something that should be, immediately taken off the table as an option. It's definitely, can be worthwhile. You just have to calculate not just, there's so many things when you're doing a calculation like this. 'Cause similarly, some things you don't know the answers to, but, if you're paying a big tax bill now versus down the road, what's the potential growth of that amount that you'll maybe lose over the next 20, 30, 50 years? Who knows? Right? So,
Yeah. Yeah, I think in the cases where that has been considered, almost every instance, the grantors will say of the trust and the parents will say typically have had their children in the United States, so the children are U.S. citizens, right?
yeah,
And I will also say that a lot of these people who, again, this applies to are STEM-based professionals. And the chance is, even though they are relocating back to Canada, and often because of the, reasons related to family and being closer to mom and dad and grandpa and grandma, there's always the outside chance that they could, in fact, relocate back to the US at some point down the road. So
for
having
sure.
that US citizenship as opposed to, the green card issue of having green cards and do you give them up? And then there's this, anyway, it's an interesting conversation, and that's why we have strategists, tax advisors, estate planning attorneys, financial advisors, all coming together to come up with a plan. Um, okay, from your experience, I got to ask this one: what do you think is the most common oversight? That's a kind way of saying mistake. Okay, common oversight Canadians make when they're repatriating back to the U.S., repatriating their estate plan, and is there a way? How do you avoid it other than don't? So, what would you say is the common mistake? We'll call it,
Canadians repatriating to the US?
from the United States to Canada.
Oh, US, Canada. Okay, sorry. Uh, the thing that I see most commonly as an oversight is quite often a misunderstanding of, we have tax treaties where the idea is you're going to pay typically the highest tax of the two countries, but you're not going to be taxed both. But it's overlooking things where the two different tax regimes don't really line up, and there's things like an RESP, Education Savings Plan,
Yeah.
RDSP if you have a disability or someone with a disability. Those things don't align, and then it causes the multiple taxations, and the net result can be really really rough if you don't plan accordingly.
I'll chime in on that one too. So, if you're a Canadian looking to move to the US, for example, your tax-free savings account that you've been funding since back when it started, once you become a U.S. resident, that is no longer an effective way of accumulating money anymore. You can't contribute anymore to it. And it's also a bit of a tax problem because the IRS views that account as basically a foreign trust, as I understand it. So, but then if you go back to Canada, let's say you're under the scenario I just outlined where it made more sense to become a U.S. citizen before relocating back to Canada, you cannot start contributing to it again because you're still basically reporting to the IRS. That's one issue. And then also on another, this is more tax and estate planning, is that uh, there are certain types of investments in Canada that if you're reporting to the IRS, that the IRS kind of they look at differently, and they call them passive foreign investment corporations or PFICs. Many retail mutual funds, exchange traded funds or ETFs, segregated funds, which are, basically a mutual fund with an insurance wrap around them, typically get known as PIVA, and they get taxed very unfavorably. They get taxed at the highest possible federal tax rate. And there's a way of getting out from underneath of that. There's a qualified election form that you can get a CPA to fill out for you, but they typically charge about, I don't know, $500 per investment. So if you have a portfolio full of a chock full of these types of investment, it becomes a real problem. So you have to be really careful when you come back to Canada. Again, if you're still reporting to the IRS of what you invest your money in, because it can be turned into a bit of an issue. Not that it can't be overcome, but these are things you need to be aware of.
Yeah,
Uh,
and quite commonly with almost all of this, it's things that can be overcome with, enough planning and enough notice, but it's sometimes tricky when we're, hey, I got to sort this out because I've got 2 weeks I'm on my deathbed and I never did any planning and now I have to figure
Oopsie.
it out. Yeah.
Well, to me, the biggest challenge, I know we're talking Canada back to the US, but I will tell you one of the biggest mistakes uh, that I have seen Canadians make, and if I don't mind interjecting the other way, moving to the US, is because of the exchange rate, which we know now is somewhere in the 71 cent range, US dollar, CAD USD. And they will leave assets behind in Canada in a taxable environment, stay invested. I've seen this. This is not fabrication. I've seen multiple situations where people have left their money in Canada, come to the US because of the exchange rate issue, and they go to, their bank in whatever city they're in the US, and the banks all say, yeah, we can handle all your money, no problem. But then you realize that, well, RSPs, I got to cash it all out and I'm going to lose about 50% of it or something to taxes. And, my taxable or my non-registered money, they can take that all too, and my TFSA money too, but they're going to want to convert it all to US dollars. And if you think about the fact that purchasing power parity now is around what, 83 cents, and current CAD value is 71, you're going to lose about 12 cents or what, or 15, 16% on your, when you make that conversion, right? So they'll leave the money in Canada and get offside with the IRS because they didn't know about all that PFIC reporting I was talking about. And God forbid, if they've never heard of an FBAR report, then they're in major trouble. So the good news is if you're working with experts like Craig, like myself, and some really skilled cross-border tax experts, none of this stuff needs to happen. Before we wrap up, before we let you go, Craig, and you've been a great guest today, as more Canadians return, from the US to Canada, are there any, I guess we should bring this up, is there any emerging trends from an estate law perspective, maybe cross-border, that people should be preparing for? Is there anything on the horizon? Is there anything that people should be thinking about if they're making that move?
Um, just that, if anything, I would say that estate law in Canada is slowly moving more and more along the trends that you see in the US, where, there's more litigation around estate plans, not the plans per se, but around estates and, people suing because they potentially didn't get what they were expecting to get. More and more popular to see if there isn't careful wording to sort of explain why someone wasn't provided for or wasn't provided for more than they were, that we are seeing more and more where people are making claims where they didn't traditionally have a claim. So, adult children who don't have disabilities, who don't have any reason traditionally to be able to sue an estate, but where they're finding avenues to make a claim on the estate saying that they were entitled to something or there was some sort of unfair action that was taken that led to them not getting a larger share. So being cautious about that, particularly when there's someone who's not getting an even share of things.
Yeah, I was in a conversation with that topic came up a couple of weeks ago, and the consensus was that a lot of times those cases get thrown out pretty quick. At least here in the U.S., it's like legal document you didn't get named in your father's estate. Uh, Sorry for being you, sort of thing. All
Yeah, I
right.
mean, the courts are always balancing that sort of, on one side, making sure that fairness reigns, but at the
Right.
same time that it's your assets and you should be able to do what you want with them.
Right. And again, the outlier, of course, is, we found out that when they drafted the trust that they weren't in their right. They were
Yeah.
diagnosed with a cognitive illness or something to that effect, or forgeries, like really things where it's other obvious that that wasn't what the real intent was.
Yeah.
Okay. We got folks watching here on our website. They're able to see us chatting here, and hopefully we've kept them educated and informed and somewhat entertained here. Um, and we've included, everybody can see how to get a hold of you. But, we have a lot of people also who listen to this on Apple and on Spotify and are listening in, and maybe they're thinking about that relocation back to Canada, back to Alberta, British Columbia. For those folks listening in, how can they get a hold of you? What's the best way for them to contact you?
Yeah, I mean, probably the best is just to go to our website, which is www.thelastword.ca. Yeah, because we're in Canada. And otherwise, they can always email me at Craig, Craig, at thelastword.ca.
All right. Well, Craig, this has been cool. I am glad we had you on. I'm glad you took the opportunity to join us on the podcast. And I'm telling you, I'm very serious. We're probably going to be having you back sooner than later. I really enjoyed the conversation, and I can see we could extend this conversation and talk about the relocation going from, we just did, going from south to north. We can also bring you back and maybe talk about going from Canada to the US, because as we both know, that's still happening regardless of all the,
Oh, absolutely.
yeah.
I haven't actually seen a slowdown in that at all. So,
Yeah, I believe it's going to grow. In fact, my personal opinion, which I should keep to a minimum, but is I think with if these all the tariff talk tops, I think it's going to expedite even more. Uh, I want to make money. If I'm an entrepreneur, I'm going to want to set up shop south of the border, most likely. So, Craig, again, thanks a lot for joining us. We'll see you soon. Craig Tervit is the founder of The Last Word, and his law firm assists with crafting comprehensive and very well thought out wills and estate plans. Thank you very much, Craig, and we shall see you soon.
thank you. Take care. Appreciate it.
I look forward to bringing you the Three Questions podcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our podcast and YouTube channels. And to receive a notification when our latest episode has been posted, please click on the notifications bell. Last but not least, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you, and we will see you soon.